Dachau, 14 August 1947. A United States military court convicts Ilse Koch in the Buchenwald case and sentences her to life imprisonment under the Dachau trial's common design doctrine. Scale is documented. The Buchenwald Memorial records approximately 277,800 prisoners, 139 satellite camps, and approximately 56,000 deaths. Fact and contrast. On 8 June 1948, United States Military Governor General Lucius D. reduces Koch's sentence to 4 years, stating there was no convincing evidence she selected inmates to harvest tattooed skin or possessed human skin items. In Augsburg, 15 January 1951, a West German court again imposes life, but for incitements to grievous bodily harm, attempted murder, and murder, not for artifacts. Open question: how did highly publicized atrocity stories outpace the narrower facts courts could prove, and what do the archival records actually show? Ettersburg near Weimar, 15 July 1937. Engineers unfold blueprints on a wooden table, their pencil marks listing 3,500 meters of electrified barbed wire fence, enclosing 400,000 square meters of prisoner area. The camp's initial designation is simple: a central detention site for political prisoners and so-called asocials. Within months, the ledgers begin to expand. Transport lists arrive from Berlin, Munich, Vienna. Names fill columns. Numbers climb. By the time the war begins, Buchenwald has become something else entirely. The expectation had been containment and punishment. The reality becomes exploitation. Forced labor becomes the engine. Armaments factories need workers. Quarries need stone. Construction projects need hands. The SS administration assigns prisoners to 139 satellite camps, subcamps scattered across central Germany. Each subcamp feeds a factory, a mine, a construction site. The demographic breakdowns recorded by camp statisticians reveal the scope. Approximately 30,000 miners pass through the system. 28,230 women are registered. Total prisoner count over the camp's lifespan, approximately 277,800. Commandants come and go. Karl Otto Koch takes command in 1937. Under his administration, corruption spreads through the SS hierarchy like rot in timber. Hermann Pister succeeds him in 1942, presiding over the camp's deadliest years. By liberation, the mortality ledger lists approximately 56,000 deaths, documented, counted, filed. These are not estimates. These are institutional records, the bureaucratic residue of a lethal system. The numbers are cold, precise, administrative. They measure a machinery of death that operated with industrial efficiency. No single act of cruelty can encompass the scale. No individual. Atrocity can explain the total. The system itself, allocation of labor, inadequate rations, medical neglect, punishment protocols, hardwires lethal conditions into daily operations. Yet within this documented horror, a smaller drama unfolds. In 1943, SS Judge Conrad Morgan opens an investigation. His target: Karl Otto Koch, Commandant of Buchenwald. The charges: embezzlement, corruption, murder of witnesses. The SS, it turns out, investigates its own. This internal record, predating Allied courts, predating liberation, establishes a paper trail. It proves that some crimes were recognized even within the Nazi apparatus. It also proves that recognition meant little when measured against the system's lethal momentum. Buchenwald, 1943. An SS judicial file lands on a desk in Berlin. Inside, financial records, witness statements, evidence of embezzlement. The name on the indictment: Karl Otto Koch, former commandant. The investigator: Conrad Morgan, an SS judge assigned to root out corruption within the camp system. The charges are precise: at least 200,000 Reichsmarks in embezzled funds. Confiscated valuables diverted to personal accounts. and something darker, the premeditated murder of 3 inmates to obstruct the investigation. The expectation within SS ranks had been internal discipline to protect institutional reputation. The investigation uncovers something else. A commandant who ran Buchenwald like a personal fiefdom, skimming profits from forced labor contracts, selling confiscated property, and eliminating witnesses who knew too much. The murders are not ideological. They are pragmatic. They are crimes of cover-up, not policy. Morgan's investigation expands. Ilse Koch, Karl Otto's wife, is charged with habitual receipt of stolen goods. The accusation: she accepted camp property, items confiscated from prisoners, and used them as her own. The trial proceeds within SS jurisdiction. Evidence is presented. Testimony is heard. On 5 April 1945, days before Germany's collapse, Karl Otto Koch is executed by SS firing squad. The sentence is carried out by the very system he served. This internal proceeding establishes a crucial precedent. Long before Allied prosecutors arrive, long before liberation, the SS' own records document criminal behavior at Buchenwald. The embezzlement tallies, the murder charges, the witness testimony, all of it preserved in German files. These are not allegations invented by victors. These are crimes recognized, prosecuted, and punished by perpetrators. Yet the punishment is selective. Karl Otto Koch dies by firing squad for theft and obstruction, not for the systematic brutality that defines Buchenwald. Morgan's investigation focuses on personal corruption, not systemic atrocity. The SS cleans house to protect itself, not to deliver justice. The irony is sharp. The Nazi regime executes a camp commandant for embezzlement, while 56,000 prisoners die from policies the regime endorses. Post-war courts will struggle with this legacy. How to prosecute Ilse Koch when her husband's corruption, documented by his own colleagues, overshadows her personal culpability. The sensational claims, human skin lampshades, tattooed skin artifacts, will dominate headlines. But the SS court records, dry and bureaucratic, establish a different baseline. They prove that crimes were known, that evidence was collected, that some killings were deemed criminal even by Nazi standards. This pre-Allied documentation becomes a reference point, a measuring stick for what can be proven versus what can be alleged. Dachau, 11 April to 14 August, 1947. A courtroom in southern Germany. 31 defendants sit in rows, guarded by American military police. The chief prosecutor, Lieutenant Colonel William Denson, opens the case. The legal framework is specific. Participation in a common design to commit war crimes at Buchenwald concentration camp. The prosecution does not need to prove that each defendant personally killed a prisoner. The theory is collective liability. If the defendants participated in the camp's operation, and the camp's operation was criminal, then all participants share guilt. Ilse Koch is among the accused. Public attention centers on her. Newspapers call her the Witch of Buchenwald, the Bitch of Buchenwald. Sensational allegations circulate: lampshades made from human skin, gloves made from tattooed flesh, a collection of grotesque artifacts. The courtroom becomes theater. Witnesses testify. Photographs are entered into evidence. The narrative is visceral, immediate, horrifying. But the legal framework operates on different logic. The common design doctrine does not require prosecutors to prove that Ilse Koch personally ordered killings or personally possessed human skin artifacts. The charge is broader: participation in the camp's criminal enterprise. If the camp itself was a machine of death, and if Koch was part of that machine, then liability attaches regardless of specific acts. On 14 August 1947, the verdict is announced. Ilse Koch is sentenced to life imprisonment. The judgment rests on her participation in Buchenwald's operations. The verdict is severe, final, public. It satisfies demands for accountability. It answers public outrage. It closes a chapter. Yet the sensational allegations, lampshades, tattooed skin, remain unproven in the courtroom. The common design framework bypasses the need for forensic evidence linking specific artifacts to specific defendants. The prosecution builds its case on the camp's documented lethality: approximately 56,000 deaths, 139 satellite camps, forced labor, medical experiments, systematic brutality. The numbers speak. The system condemns. Individual acts become secondary. This legal strategy secures convictions but leaves questions unresolved. If Koch did not personally order killings, what exactly did she do? If artifacts cannot be forensically linked to her, why do they dominate the narrative? The DACA verdict answers these questions with silence. Life imprisonment is the sentence. The public is satisfied. The record, however, remains incomplete. Within the American military justice system, a mandatory review process activates. Every sentence from a military commission must be reviewed by higher authorities. The file moves through the Judge Advocate General's office. Deputy Judge Advocates read transcripts. The War Crimes Review Board examines evidence. Questions arise. Standards of proof are debated. The sensational claims that dominated the trial now face scrutiny in offices far from the courtroom. A reassessment begins, quiet and bureaucratic, that will unravel the verdict within 12 months. Frankfurt and Washington, 1947 to 8 June, 1948. A file circulates among lawyers. The case, United States versus Ilse Koch. The question, does the trial record support the life sentence? Deputy Judge Advocate officials pull transcripts, reread witness statements, examine physical evidence inventories. What they find troubles them. The review board notes inconsistencies. Witnesses testified about human skin artifacts, but forensic evidence linking those artifacts to Koch is weak. Chain of custody problems emerge. Some exhibits shown at trial cannot be traced to specific seizures at Buchenwald. Other exhibits, while disturbing, lack documentation proving Koch ordered their creation or even possessed them. The record, officials conclude, contains little convincing evidence that Koch selected inmates for their tattoos or that she owned human skin items. Harold Kuhn and Richard Schneider, lawyers in the Deputy Judge Advocate's office, draft memoranda. Colonel J. L. Harbaugh, reviewing the case file, concurs. The sensational charges that dominated headlines rest on shaky foundations. The legal theory of common design secured the conviction, but that theory does not require proof of the artifact allegations. The question becomes, if the sensational claims cannot be proven, does the remaining evidence justify life imprisonment? The file reaches General Lucius D. Clay, United States military governor in Germany. Clay reviews the recommendations. On 8 June 1948, he issues his decision. The sentence is reduced from life imprisonment to 4 years. His written rationale is precise. There was no convincing evidence that Koch had selected inmates for the purpose of having them killed to obtain tattooed skins, or that she possessed any articles made of human skin. Clay's language is careful, lawyerly. He does not declare Koch innocent. He does not exonerate her. He states only that specific allegations lack convincing proof. The reduction is a legal judgment, not a moral absolution. Yet the public reaction is immediate and fierce. Newspapers condemn the decision. Veterans groups protest. Members of Congress demand explanations. How can the witch of Buchenwald serve only 4 years? Clay, in subsequent statements, clarifies his position. The artifact charges were not proven, he explains, but Koch remains culpable under German law. She can be prosecuted by German courts for crimes against German nationals. The reduction does not end her accountability. It merely separates what can be proven from what cannot. The distinction is crucial for legal integrity, but unpersuasive to a public shaped by liberation photographs and atrocity narratives. The review process exposes a tension at the heart of war crimes prosecutions. Public memory demands certainty. Legal standards demand proof. When the two diverge, decisions become political as well as judicial. Clay's order reduces a sentence but cannot reduce the intensity of public belief. The legend of Ilse Koch, built on sensational claims, persists regardless of what military lawyers conclude about evidentiary standards. Augsburg, near Weimar, 1937 to 1945. Post-war curators sit in archive rooms sorting through SS records, transport manifests, death registers. Their task, to produce an accurate accounting of Buchenwald's scale. The numbers they compile become the authoritative baseline cited in museums, history books, and legal proceedings. The final statistics are stark. Approximately 277,800 prisoners pass through the Buchenwald system. 139 satellite camps operated under Buchenwald's administration. Approximately 56,000 deaths are documented, some recorded in camp ledgers, others reconstructed from transport records and survivor testimony. The mortality calculation includes deaths in the main camp, deaths during forced evacuations in April 1945, and deaths in subcamps. Each category is methodologically distinct. Each number represents painstaking archival reconciliation. The demographic breakdowns reveal additional dimensions. Approximately 30,000 minors were imprisoned at Buchenwald. 28,230 women passed through the system. Political prisoners, Jews, Roma, prisoners of war, so-called asocials. Each category has its own statistical profile. The diversity of victims underscores the camp's function as a catch-all detention and exploitation site. These numbers exist independently of sensational narratives. Lampshades and tattooed skin dominate public memory, but archivists focus on systemic lethality. Forced labor, inadequate rations, medical neglect, overcrowding, disease. These are the documented causes of mass mortality. In early April 1945, more than 47,000 inmates were crammed into the main camp on Ettersberg Mountain, a site designed for far fewer. Typhus outbreaks spread, food supplies collapsed, death rates spiked. These are the facts that define Buchenwald's criminality. The memorial's methodology is transparent. SS records, when available, provide baseline counts. Survivor testimony fills gaps. Cross-referencing transport lists with liberation rosters identifies discrepancies. The result is not a perfect ledger. Nazi bureaucracy was efficient, but not infallible. But it is the most reliable accounting available. International historians and Holocaust institutions accept these numbers as authoritative. The contrast between memorial statistics and trial narratives is instructive. Courts focus on individual culpability. Memorials document systemic outcomes. The two perspectives converge on the same conclusion. Buchenwald was a site of mass atrocity. But they reach that conclusion through different methods. Courts need perpetrators. Memorials need numbers. Both are necessary. Neither is sufficient alone. Augsburg courts in later proceedings will use these statistics as context. Prosecutors will cite the 56,000 deaths to establish the camp's lethality. Defense attorneys will note that Ilse Koch arrived at Buchenwald after the system was already operational. The numbers anchor the case but do not resolve questions of personal liability. They prove the crime. They do not by themselves identify the criminal. Germany and the United States, 1945 to 1948. American soldiers advancing through Thuringia in April 1945 reach Buchenwald. They carry cameras. Signal Corps photographers document everything: emaciated prisoners, piles of corpses, primitive barracks, evidence of medical experiments. The images are shocking, immediate, undeniable. They circulate quickly: military reports, press releases, newsreels. Within weeks, the world sees Buchenwald. Early exhibits accompany the photographs. Provisional displays appear in military courtrooms and occupation headquarters. Objects seized from the camp Artifacts claimed to be made from human remains are photographed and cataloged. Captions describe lampshades, book covers, gloves. The visual record shapes public understanding. Liberation imagery creates a narrative of unambiguous horror. But the evidentiary chain proves problematic. Photographs show objects. They do not show who made those objects, who owned them, or how they arrived at the locations where they were found. Forensic analysis, where conducted, produces ambiguous results. Some items tested as human tissue, others did not. Provenance, the documented history of an object's ownership and location, is often incomplete. Chain of custody records, essential for courtroom admissibility, are inconsistent. Legal scholarship later examines this gap. Mark A. Drumble, analyzing Holocaust trials decades after the fact, notes that proceedings served as visual spectacles as much as legal adjudications. Public memory was shaped by what people saw: photographs, artifacts, visceral testimony. But courtroom standards required more. Prosecutors needed to link objects to defendants. They needed documentation. They needed forensic certainty. Often they did not have it. Thomas Jardim, studying the gendered construction of Ilse Koch's infamy, argues that sensational allegations amplified because they fit narrative patterns. The evil woman, the sadistic wife, the sexual predator. These tropes made Koch infamous beyond what evidence could support. Media framing outpaced judicial findings. Public outrage exceeded legal proof. The liberation images remain powerful. They document Buchenwald's reality upon discovery. They prove the camp's lethality. They establish why prosecutors pursued war crimes trials. But they do not, by themselves, prove individual criminal acts by named defendants. That requires a different kind of evidence: orders, testimony, forensic linkage. The gap between what photographs show and what courts can prove becomes a recurring problem in Koch's legal saga. As United States authorities prepared to release Koch in October 1949, her 4-year sentence nearly complete, Bavarian prosecutors act. On the day of her scheduled release, German authorities execute an arrest warrant. The case transfers from American to German jurisdiction. A new trial begins, operating under German law, with different evidentiary standards and a narrower focus: crimes against German nationals. Landsberg Prison and Augsburg, October 1949 to November 1950. Ilse Koch calculates her release date: 4 years from conviction in Dachau, October 1949. She expects freedom. The prison gate opens. German police wait outside. An arrest warrant is served. She is transferred to Bavarian custody. A new legal process begins. Bavarian Chief Prosecutor Johann Ilkau assembles a case. The legal framework differs from the American trial. United States military commissions operated under occupation law, applying broad liability theories like common design. West German courts apply the German Penal Code. Prosecutors must charge specific offenses: assault, incitement to assault; murder, incitement to murder. Each count requires evidence linking Koch to a named victim or a documented incident. The indictment, when finalized, lists 25 counts of grievous bodily harm. The charges detail instances where Koch allegedly ordered beatings, punishments, or abusive treatment. Additional counts include approximately 65 incitements to attempted murder and 25 incitements to murder. The German legal concept of incitement holds individuals liable for ordering or encouraging others to commit crimes. If Koch ordered guards to beat a prisoner knowing the beating could be fatal, she incites murder. The scope of the case is ambitious. Prosecutors plan to call approximately 250 witnesses. Survivor testimony will anchor the charges. Victim names will be specified. Incidents will be dated. The trial will focus on provable acts, not abstract participation in a system. This narrowing of focus shifts the legal terrain. Prosecutors must prove Koch did specific things to specific people. The broad common design theory is unavailable under German law. Public attention remains intense. Newspapers speculate about lampshades and tattooed skin, but prosecutors, reviewing the evidence, make a strategic decision. The human skin allegations lack sufficient forensic proof. Artifacts cannot be reliably linked to Koch. Provenance is uncertain. The charges in the indictment omit the sensational claims. The case will proceed on incitement and assault, not artifacts. This decision is pragmatic. Prosecutors prioritize winnable charges. Incitement can be proven through witness testimony. Guards and survivors can testify about orders Koch gave. Documents show her presence and authority at the camp. The case is strong on these grounds. Adding artifact allegations, with their evidentiary weaknesses, risks undermining the prosecution. The trial is scheduled to open 27 November 1950. 7 weeks are allotted for testimony. The courtroom in Augsburg prepares for a lengthy proceeding. Defense counsel files motions. Witnesses are summoned. The case, jurisdictionally transferred from American to German authority, will test whether West German courts can achieve what American tribunals struggled to accomplish: definitive legal accountability for Ilse Koch based on provable criminal acts. Augsburg, 27 November 1950-15, January 1951. The courtroom fills daily. Presiding judges take their seats. Prosecutors present evidence. Defense counsel cross-examine. Survivors testify, recounting orders Koch gave, punishments she inflicted, incidents she instigated. Medical files document injuries. Guard testimony corroborates survivor accounts. The trial proceeds methodically, building a case from documented incidents. The sensational allegations surface during testimony. Witnesses mention tattooed skin and lampshades. The courtroom listens. But prosecutors, having reviewed the evidence in pretrial proceedings, do not press these claims. The indictment already omitted artifact charges. The focus remains on incitement and assault. Did Koch order beatings? Did she incite guards to kill prisoners? Can specific incidents be documented with named victims and corroborating testimony? The answer, according to the court's findings, is yes. The written judgment, 111 pages long, details convictions on multiple counts. Koch is found guilty of 7 counts of incitement to grievous bodily harm. She is found guilty of 1 count of incitement to attempted murder. She is found guilty of 1 count of incitement to murder. The court concludes that Koch, during her time at Buchenwald, ordered guards to assault prisoners in ways likely to cause death or serious injury. Her authority was real. Her orders were followed. Prisoners suffered and died as a result. On 15 January 1951, the court imposes a life sentence. The verdict rests on provable criminal acts, not on sensational allegations. The human skin charges which dominated public perception are absent from the judgment. The court convicts on incitements, specific orders to commit specific harms against specific victims. This legal core is narrower than public expectation, but stronger in evidentiary terms. Defense counsel files an appeal. The case moves to the Federal Court of Justice, Germany's highest criminal court. On 22 April 1952, the appeal is dismissed. The verdict stands. The life sentence is confirmed. Ilse Koch will remain imprisoned. The Augsburg trial converts diffuse atrocity narratives into specific criminal liability. It proves that legal accountability does not require proving every alleged horror. Courts can convict on documented acts even when sensational claims cannot be sustained. The gap between public belief and judicial findings remains, but the verdict establishes a factual baseline. Koch incited violence, prisoners died, the law holds her accountable. This legal resolution, however, does not end controversy. Media continues to reference lampshades and tattooed skin. Public memory persists independently of court records. The legend of Ilse Koch, built on sensational allegations, outlives the narrower judicial findings. 2 life sentences, one from Dachau in 1947, one from Augsburg in 1951, establish her guilt. But the crimes for which she is legally accountable differ from the crimes the public believes she committed. Dachau and Augsburg, 1947 to 1952. 2 trials, 2 legal systems, 2 verdicts. Both impose life sentences. Both hold Ilse Koch accountable for crimes at Buchenwald. But the legal frameworks diverge. Comparing the judgments reveals how different systems approach the same defendant. The Dachau trial operated under American military law. The legal theory was participation in a common design to commit war crimes. Prosecutors did not need to prove Koch personally killed anyone. They argued that Buchenwald itself was a criminal enterprise, a machine of death, and that anyone who participated in its operation shared collective guilt. The court agreed. Life sentence. The verdict rested on broad liability. Koch was part of the system. The system was criminal. Therefore, Koch was guilty. The Augsburg trial operated under German criminal law. The penal code requires specific offenses: assault, murder, incitement. Prosecutors charged Koch with ordering guards to beat prisoners, sometimes fatally. Each count required a named victim, documented incident, and corroborating testimony. The court convicted on specific acts: 7 counts of incitement to grievous bodily harm, 1 count of incitement to attempted murder, 1 count of incitement to murder. Life sentence. The verdict rested on narrow liability. Koch ordered specific harms. Those harms occurred. Therefore, Koch was guilty. Both trials confronted the human skin allegations. Both courts declined to convict on those grounds. At Dachau, the common design framework bypassed the need for artifact evidence. Liability attached regardless. At Augsburg, prosecutors dropped the charges for lack of proof. In both cases, the sensational claims that dominated public attention were legally peripheral. The verdicts rested on other grounds. General Lucius D. Clay's language from the 1948 review remains the clearest statement of evidentiary limits. There was no convincing evidence that Koch had selected inmates for the purpose of having them killed to obtain tattooed skins, or that she possessed any articles made of human skin. This sentence, technical and careful, draws a line between what was proven and what was alleged. Courts could not sustain convictions on artifact charges. They could, and did, convict on other crimes. The divergence between public legend and judicial findings creates a historical puzzle. Why do the sensational allegations persist if courts twice decline to convict on those grounds? Part of the answer lies in timing. Liberation photographs shaped public understanding before trials began. Media coverage emphasized artifacts because they were visceral, immediate, photogenic. By the time courts issued verdicts, public memory was already formed. Legal findings could not dislodge established narratives. Another part of the answer lies in the nature of atrocity. The scale of Buchenwald, 56,000 deaths, forced labor, medical experiments, systematic brutality, is too large to grasp as individual acts. The human mind seeks focal points, symbols, specific horrors that represent the whole. Lampshades and tattooed skin serve that function. They are tangible, grotesque, comprehensible. They reduce vast systemic evil to a scale the imagination can process. Whether courts sustain those charges becomes secondary to their narrative power. The legal record, however, remains important. 2 courts, applying different legal systems, both imposed life sentences. The crimes they proved, participation in a criminal system, incitement to murder, are severe. The sentences are just. The artifact allegations, while unproven, do not diminish the gravity of established guilt. Koch's legal culpability stands on documented grounds. The legend may persist, but the facts anchor history. Ettersburg and subcamps, 1937 to 1945. A final audit. Post-war memorial institutions compile comprehensive statistics. Transport lists are cross-referenced. SS records are verified. Survivor testimony fills gaps. The result is the authoritative ledger, approximately 277,800 prisoners, 139 satellite sites, approximately 56,000 deaths. The peak of congestion occurred in early April 1945. More than 47,000 inmates were crammed into the main camp on Ettersberg Mountain. Liberation was days away. The SS was evacuating prisoners from camps farther east. Transport trains arrived overloaded. Barracks designed for thousands held tens of thousands. Disease spread. Food supplies collapsed. Death rates reached their highest levels. When American forces arrived on 11 April 1945, they found survivors on the edge of death and thousands already dead. The statistical record documents a system where lethality was structural, not incidental. Forced labor policies allocated prisoners to armaments factories, quarries, construction sites. Work conditions were brutal, rations were inadequate. Medical care was minimal or weaponized. Doctors conducted experiments rather than providing treatment. Punishments were severe and often fatal. The SS administrative apparatus documented everything: prisoner arrivals, work assignments, deaths. This bureaucracy, grotesque in its efficiency, preserved the evidence of its own crimes. The demographic breakdowns reveal additional patterns. Approximately 30,000 minors passed through Buchenwald. Children, some barely teenagers, were subjected to the same labor demands and brutal conditions as adults. 28,230 women were registered. While Buchenwald was primarily a male camp, women prisoners, many transferred from Ravensbrück, faced gender-specific abuses alongside systemic brutality. Political prisoners, Jews, Roma, prisoners of war, so-called asocials. Each group has its mortality profile, each documented in camp records. These numbers stand independently of individual perpetrators. The system killed. Specific individuals, commandants, guards, functionaries, facilitated that killing. But the scale of death exceeds what any individual could personally inflict. This is systemic lethality, embedded in policies, logistics, and administrative procedures. Courts prosecute individuals. History documents systems. Both perspectives are necessary to understand Buchenwald. The contrast between systemic mortality and individual culpability creates legal challenges. How does a court hold one person accountable for 56,000 deaths? The answer: it does not. Courts focus on provable acts by specific defendants, participation in the system, orders given, harms inflicted. The larger mortality serves as context, proof that the institution was criminal, but convictions rest on narrower grounds. This is why Ilse Koch's trials focused on incitements and assaults, not on the camp's total death toll. The memorial's statistical work serves a different purpose than trials. It establishes the baseline of fact. It answers questions about scale, scope, and structure. It provides the numbers future generations will use to understand what happened. These numbers, 277,800 prisoners, 56,000 deaths, do not change. They anchor history even as interpretations evolve. They define Buchenwald's place in the historical record. Eichach Prison, 1951 to 1967. Ilse Koch begins a life sentence. The Augsburg verdict is final. The appeal to the Federal Court of Justice fails on 22 April 1952. The legal process concludes. Imprisonment begins. Clemency petitions follow. Defense attorneys file requests with Bavarian justice officials. The arguments vary. Some petitions claim procedural errors. Others request sentence reduction on humanitarian grounds. Koch undergoes psychiatric evaluations. Reports are added to the file. Prison officials document behavior, health, state of mind. The clemency process, bureaucratic and slow, consumes years. Public rumors circulate periodically. Claims that Koch will be released, that pardons are imminent, that political pressure will secure her freedom. Newspapers report these rumors. Survivors protest. Veterans groups mobilize. Each time, the rumors prove unfounded. Pardon requests are denied. The life sentence stands. The Federal Court of Justice dismissal in 1952 establishes firm legal ground. The Augsburg judgment, reviewed and upheld by Germany's highest criminal court, is no longer subject to further appeal. Clemency remains a possibility. German law allows executive pardons, but judicial review is exhausted. The verdict is legally final. Koch's imprisonment continues through the 1950s and into the 1960s. Eichach Prison, a women's facility in Bavaria, becomes her permanent residence. The facility is secure but not harsh by post-war standards. Prisoners have routines, limited privileges, occasional visitors. Koch ages in confinement. The world outside changes. West Germany rebuilds. The economic miracle transforms the country. Cold War tensions define European politics. Koch's imprisonment becomes historical background, a settled fact. On 1 September 1967, Koch is found dead in her cell. The cause? Suicide. The means? She hanged herself. No clemency had been granted. No pardon was imminent. She died serving the life sentence imposed 16 years earlier. The legal saga, spanning 2 trials and 2 decades, ends not in a courtroom, but in a prison cell. The archival record closes. Case files are sealed. Clemency petitions are filed away. The factual baseline is established. 2 life sentences, 1 reduction, no conviction on human skin artifacts. Buchenwald, approximately 56,000 deaths. These are the documented facts. They define the historical record. They will not change. Germany and the United States, 1945 to present. Decades after the trials, scholars return to the case. Their questions are not legal, but historical. How did sensational allegations outpace judicial findings? Why does public memory diverge from court records? What does the Koch case teach about atrocity prosecutions? Mark A. Drumble, analyzing Holocaust trials in the 21st century, notes that proceedings served as visual spectacles. Public understanding was shaped by what people saw: photographs, artifacts, testimony. Legal proof operated differently. Courts required forensic linkage, documented evidence, procedural rigor. The gap between public spectacle and legal adjudication created lasting misunderstandings. What people believed happened did not always align with what courts could prove. Thomas Jardim, examining gendered aspects of Holocaust memory, argues that Ilse Koch's notoriety relied on narrative tropes: the evil woman, the sadistic wife, the sexual predator. These tropes amplified her infamy beyond what evidence supported. Male perpetrators, commandants, guards, administrators, were prosecuted based on their roles and actions. Female perpetrators, far fewer in number, were often framed through gendered lenses. Koch became the Witch of Buchenwald not only because of her crimes, but because her gender made her a more sensational villain. Legal scholarship examines evidentiary standards. Common design liability, used at Dachau, secured convictions, but bypassed difficult proof problems. If the system was criminal, participants were guilty. This theory worked for prosecution, but left unresolved questions about individual culpability. German incitement charges, used at Augsburg, required narrower proof, specific orders to specific guards resulting in specific harms. This theory worked for conviction, but depended on survivor testimony and documentary evidence. Neither approach fully satisfied demands for comprehensive accountability. Museum institutions contribute to this analysis. The Buchenwald Memorial compiles baseline statistics, preserves documents, and maintains exhibits. Its role is not judicial. It does not determine guilt or innocence. Its role is memorial, to document what happened, to honor victims, to educate the public. The memorial's statistical ledgers, 277,800 prisoners, 56,000 deaths, provide the factual foundation for historical understanding. The intersection of law, evidence, and memory becomes the scholarly focus. Courts must operate within legal constraints. Public memory operates differently, shaped by imagery, emotion, and narrative. The two domains overlap, but do not align. This divergence explains persistent controversies. People believe what liberation photographs showed them. Courts prove what evidence allows. When the two diverge, confusion and frustration result. The Koch case teaches several lessons. First, sensationalism obscures more than it reveals. The lampshade allegations dominated attention but were legally peripheral. The provable crimes, incitement to murder, participation in a lethal system, were severe enough to warrant life sentences. Second, legal findings do not control public memory. Even when courts decline to convict on specific charges, public belief persists. Third, evidentiary rigor is essential but often misunderstood. General Lucius D. Clay's statement, "No convincing evidence of tattooed skins or human skin articles," was a legal judgment, not a moral exoneration. It separated what could be proven from what could not. This distinction is crucial for justice, but difficult for public comprehension. The final lesson is that documented crimes define history, not legends. Buchenwald's mortality, 56,000 deaths, is established fact. The camp's forced labor system, brutal conditions, medical experiments, and systematic violence are documented beyond dispute. Individual perpetrators, including Ilse Koch, facilitated this system. Courts held them accountable for provable acts. The sensational allegations, whether proven or not, do not alter the baseline reality. The numbers remain, the crimes remain, the history remains. Augsburg, Weimar, Washington. A closing tally. The ledger is simple, factual, complete. 2 life sentences. Dachau, 14 August, 1947. Augsburg, 15 January, 1951. 1 sentence reduction. Clay's order, 8 June, 1948, reducing Dachau's life term to 4 years for lack of convincing evidence on artifact charges. No court conviction on human skin allegations despite their prominence in public discourse. Buchenwald's documented mortality, approximately 56,000 deaths. General Clay's rationale remains the clearest articulation of evidentiary limits. His review found no convincing evidence that Ilse Koch had selected inmates for the purpose of having them killed to obtain tattooed skins, or that she possessed any articles made of human skin. This sentence, precise and measured, defines what courts could and could not prove. It does not minimize her guilt, it clarifies the legal basis of her guilt. Koch's legal fate rests on 2 pillars. First, participation in Buchenwald's criminal system, proven under the common design framework at Dachau. Second, specific incitements to grievous bodily harm and murder, proven under German law at Augsburg. Both verdicts resulted in life sentences. Both sentences were legally sound. Both were upheld on appeal. Koch died in prison in 1967, serving the Augsburg sentence, her legal accountability firmly established. Buchenwald's systemic lethality remains the immovable frame. Approximately 277,800 prisoners passed through the camp system. 139 satellite camps operated under its administration. Approximately 56,000 prisoners died from forced labor, starvation, disease, medical experiments, executions, and brutality. These numbers are documented, verified, and accepted by historians worldwide. They define the crime independent of individual perpetrators. They establish the context in which all trials occurred. The divergence between public legend and judicial record persists. Sensational allegations created a narrative that courts could not fully sustain. But the verdicts themselves, 2 life sentences, one upheld after rigorous review, establish accountability on solid legal ground. Ilse Koch was guilty. The courts proved it twice. The crimes for which she was convicted, participation in a lethal system, incitement to murder, were severe. Justice, within legal constraints, was done. History's task is different from justice's task. Courts determine guilt. History documents what happened. The two intersect but do not align perfectly. The Koch case demonstrates this. Legal proceedings established criminal liability. Historical records established the camp's scale and lethality. Both are necessary. Neither alone is sufficient. The final line is this. Documented crimes define history. Approximately 56,000 people died at Buchenwald. Their deaths resulted from systemic policies, brutal conditions, and individual acts of cruelty. Courts held perpetrators accountable for provable acts. Memorials preserve the numbers and names. Public memory wrestles with sensational narratives. But the baseline does not change. The deaths happened. The numbers are real. The responsibility is documented. Legends do not alter facts. The ledger remains.